Hello, I'm Colin Beaumont, solicitor in private practice. I've been a lawyer now in one form or another for the last 30 years. I just want to talk to you today about a few things which are current and which I think as criminal lawyers we really do need to keep an eye on. The first issue is in relation to a defendant's costs order. Now, as you know, in certain circumstances, as a result of the Prosecution of Offences Act 1985, Section 16, we may, on occasion, be able to claim the defendant's costs from public funds by way of an order for taxation where we're successful at court. We had an interesting case last year, which was the case of Spiteri v Basildon Crown Court, in which a judge refused a defendant's costs order, saying effectively that the defendant had been acquitted on an unmeritorious technicality, and in any event he'd brought the prosecution upon himself. Well, I'm sure you'll agree that a lot of our criminal clients do bring the prosecutions upon themselves, but that's not really the test for refusal of a defendant's costs order. So the defence went off to the High Court, and the High Court quashed the judge's refusal to grant the order, effectively stating that the test was that the defendant had brought the prosecution upon himself and had misled the prosecution into believing that the case is stronger against him than it actually was. Now, very few, I would have thought, of our clients meet the second limb of that particular test. There was a decision, and you may have read it in the Times some 3 weeks ago. It was a decision of Europe, the case of Ashenden and Jones. Now, I've got to get this judgment, and I think you've got to get the judgment as well, and we've got to read it, because the European Court said that in certain instances a suspect no commenting the interview at the police station stage could be interpreted as that particular defendant misleading the prosecution into believing that the case is stronger against him than it actually is. Now, I'm a bit concerned about that decision because it seems to offend against the principle that a suspect doesn't have to say anything at all and could be mute at the police station stage. If you think about it, the European judges, they are more into an inquisitorial system rather than the adversarial system we have. So part of me can understand how European lawyers might take the view, operating within the context of an inquisitorial system, that a suspect really should get involved at the very early stage of an investigation and should answer questions and give an account if an account is plausible and feasible in all the circumstances. But we don't have that system. We operate really in a more adversarial system, and for years and years and years, of course, we've been advising our clients to go no comment, where we've taken the view that there's no merit in that particular client talking at an early stage in the investigation process. Now, we really are going to have to consider this judgment quite seriously, because if you think about it, we're going to have to consider at a very early stage when advising our clients in the police station, if we're going to give advice for him or her to no comment, that might have an adverse effect at the conclusion of the proceedings in the event of there being discontinuance or no evidence offered or an acquittal after a trial. The judge or the magistrates may say no defendant's costs order. Now, I know that it's not going to affect us as lawyers because of course we'll still be able to claim the fee from our client, but we are under a duty, aren't we, to do the best for our client as regards recouping their costs, and we're also under a duty to keep them informed at every stage of the proceedings of anything which might affect them vis-à-vis costs. Well, there you are. If I could turn now to the Legal Aid Sentencing and Punishment of Offenders Bill, which, as you know, is due to come our way sometime in 2012, possibly around June. There are things which will affect us as criminal lawyers, and I'll just run through them briefly if I may. Firstly, the Act will abolish the power of a Crown Court judge to grant a defendant's costs order, which clearly may well be significant. Secondly, defendant's costs orders, if they are granted by a court, and no doubt that will be the magistrate's court, if they are granted by a court, the sums will be capped at legal aid rates. Thirdly, there will be no opportunity to apply for a defendant's costs orders for a company. Furthermore, there is going to be, and please don't ask me how it's going to work because I'm not sure, there's going to be means testing for advising clients at the police station stage, and also an interests of justice test for advising clients at that early stage of the investigation in the police station. The lawyer in me thinks it can only be bad news. First of all, from a fee perspective, and secondly, clients at the police station may take the view that they're simply going to go without a lawyer. We also need to have regard to another bill that's going through the House at the moment, which is the Protection of Freedoms Bill, which is due to come online again next year. There are going to be a number of interesting issues in this particular piece of legislation. I'd just like to deal with one, if I may, in the time available, and that is the destruction of samples. We know, because Europe told us back in 2008, that it's really unlawful and a violation of Article 8 for the samples to be kept where the defendant has been acquitted, or the defendant was not even a defendant in the sense of he was never charged. Now, the government had given some thought to what Europe had said in that case of MARPA back in 2008, and had enacted the Crime and Security Act 2010, Section 14. Section 14 set out the various time periods in which samples could be retained. But, and it's a big but, Section 14 is not going to be brought into force. The coalition government have in mind their own plans, and these are contained in the Protection of Freedoms Bill, which, as I said earlier, is likely to be with us in 2012. So we'll have a look for the Act and see what the time periods are going to be. At the moment, in the absence of any legislation, of course, we fall back on PACE, Section 64, which tells us that the samples can be kept forever. So there you are, watch this space. It's probably going to change next year. Can I also now have a word or two about some interesting case law which came out last year? Thornton was a very, very good case in relation to the principle of legitimate expectation. I'm sure you know that where something is held out to a defendant on an adjournment by way possibly of a particular sentence, then that expectation should be honoured, because a legitimate expectation has been created in the mind of the defendant that he or she will be dealt with in that particular way. And the case law is fairly legion on the subject. We could go back to Feltham Justices, ex parte Rees. We've got the case of Merritt and Peterborough Magistrates Court. There are other cases. Thornton is the latest case on the topic, because what happened here was that the magistrates adjourned the case proposing a community-based penalty. And when it came before the court on the next occasion, the defendant was actually given a suspended sentence of imprisonment. So off the defence lawyers went to the High Court challenging that sentence on the basis that it offended against the principle of legitimate expectation, and the High Court said something very interesting. They said they were not going to quash or in any way alter the sentences given by the court on the latter occasion because the indication as given by the earlier court had been so far outside of the guidelines such that it could not, in their words, possibly have raised in the mind of Mr. Thornton a legitimate expectation that he would be dealt with in that particular way. Well, excuse me, I'm pretty sure as a defence lawyer that that's exactly what it did. We've also been told in earlier cases that the legitimate expectation principle need not be honoured if the latter court takes the view that the earlier indication should never have been given because it was in some way perverse or Wednesbury unreasonable. So watch out. All I'd say to you is, if you're going to go to the High Court because your client is upset that the principle as indicated by the earlier court hasn't been followed, choose your fights carefully, because you're not going to win if the earlier indication was in any way perverse or Wednesbury unreasonable, and it seems following the case of Thornton that you're not going to win if the indication given was outside of the guideline sentence. It seems to me you could interpret the case of Thornton as meaning that the indicated sentence is now not what the court is saying, but rather the indication as given in the guidelines.